Welcome to the second and final part of the lecture on case law selection and analysis. At the end of part A of the lecture, we looked at sub-step A of the process of sifting through the multiple cases you may have found in your research to determine which of those cases are on point. That is the same or substantially similar to your client's problem that you're researching on various points of key comparisons. Now, once you have determined which cases are on point, and especially if you have multiple cases on point, then substep B will involve ascertaining the weight that those cases on point will potentially carry in your client's court, or if your client's not yet in a court, the court that would be involved were your client's case to go to court. So, in other words, determining that a case is on point is only part of the story. You need to determine then, of the cases on point that you found, which ones would carry the greatest weight as precedent in your client's court or potential court. Now, this idea of a case carrying a certain degree of weight in a particular court is sometimes called precedential weight. That is weight as precedent. And this term refers to the likelihood that a particular precedent will be followed by a particular court, assuming that that precedent is on point. Now, one of the most important determinations you can make in ascertaining weight is determining which cases on point are binding on the court that your client is in or would be in. Now, the US legal system follows the doctrine called stare decisis, a Latin phrase that means let the decision stand, or to stand on things decided. Now, under the doctrine of stare decisis, a court must follow a case on point when deciding a current dispute if the case on point qualifies as a binding precedent. Now, whether a case on point is going to be binding on a particular court will depend on two factors. What is the particular court that's currently deciding the new case, and what court decided the earlier opinion that is on point? And so the basic test for whether a case on point is binding on a particular court is that it is binding if the court that decided the precedent is either the same court that is deciding the current dispute. That is, courts are bound by their own prior decisions, or alternatively, the court that decided the case on point was a higher court than the current court, but in the same jurisdiction as that court. So a binding precedent is a case that was issued by either the same court that is deciding the current dispute, or a higher court in the same jurisdiction as the court that is deciding the current dispute. Now, if this test is not met for a particular precedent, then a case in point would be instead what we call persuasive precedent. Now, in the absence of any binding precedent, the parties can cite to the court persuasive precedent. That means a case on point that does not meet the standard for a binding precedent, but would argue that and try to persuade the court to follow it. Now, in that situation, when there is no binding precedent, but there is persuasive precedent, well, the court is free to consider the persuasive precedent, but since it's merely persuasive, the court would not be required to follow it if the court didn't want to. So that's the difference between binding precedent and persuasive precedent. And of course, when you're weighing cases on point, for the ones that will carry the greatest weight in your client's court, binding precedent will be at the very top of the list. So let's look at this graphically to illustrate the difference between binding precedent and persuasive precedent. So if you have a court opinion that is on point and it is a decision issued by the same court that your client is currently in or potentially could be in, or if it's a decision by a higher court in the same jurisdiction as your client's current or potential court, then that precedent will be binding or mandatory. Again, assuming it's on point. Any other decision would be merely persuasive precedent that the court would be free to follow or not to follow if there is no binding precedent that the court would be required to follow. Now, one thing to know about the doctrine of stare decisis, though, is that particularly at the Supreme Court level, such as the US Supreme Court or the Texas Supreme Court, courts sometimes do break with their own precedents in light of changes in society or technology or sociological factors where the court believes that one of its earlier decisions was wrongly decided. And so the court may break with its own precedent and rule a different way or overrule one of its own prior rules of law. Now, this does happen sometimes, and a very famous example is the US Supreme Court's opinion in Brown versus Board of Education, in which the US Supreme Court reversed, or excuse me, overruled it's the earlier decision in a case called Plessy versus Ferguson, in which the court back then had held that racially segregated government schools did not violate the US Constitution because these schools were separate but equal. Well, later, the court revisited the issue in Brown versus Board of Education and concluded that Plessy versus Ferguson was wrongly decided. And so the court broke with its own precedent in Plessy and held that racially segregated government schools are not separate but equal in Brown versus Board of Education. So sometimes courts do break with precedent. Typically, it will be by the highest court because lower courts are going to really still be bound by the decisions of the higher courts in their own jurisdictions. Now let's look at an example first from the federal court system at how about which courts would be higher courts in the same jurisdiction. I mean, remember the two-part test for whether a precedent is binding on a particular court involves the first prong, which would be if the precedent was decided by the same court that your client is in. So that's pretty simple. But what about the alternative prong, in which the precedent would be binding if it is decided by a higher court in the same jurisdiction as your court? Well, let's look at this first off in the federal court system. So I've got here a chart, and the left-hand column will be the type of court that your client is currently in, and then in the right-hand column, we'll look at what courts would constitute a higher court in the same jurisdiction as that court. So let's assume first that your client has a case in the one of the United States district courts, that is the trial court in the federal court system, or one of the other more specialized federal trial courts. Okay, so if that's your client's current court, then if you have a case on point from the following two courts, they'll be binding on your client's court. The first is a case on point issued by the U.S. Circuit Court of Appeals that has jurisdiction to hear appeals from your client's court will be binding authority on your client's court. Now, it's not going to be just any U.S. Circuit Court of Appeals opinion that's going to be binding. It would have to be an opinion by the U.S. Circuit Court of Appeals that would specifically have appellate jurisdiction over your client's court in the event that a losing party appealed. So if you are in the U.S. district, either any of the 4 U.S. district courts in Texas, for example, then the opinions on point issued by the Fifth Circuit Court of Appeals in New Orleans would be binding on your court, because that's the court that has appellate jurisdiction over federal trial court judgments when those courts sit in Texas, as well as Louisiana and Mississippi. Now, of course, the other higher court in the same jurisdiction would be the U.S. Supreme Court, which is, of course, above all of the federal courts. And so opinions of the U.S. Supreme Court would be binding on the U.S. District Court or other federal trial court also. Well, let's look at another scenario. What if your client has a case pending in one of the 13 federal circuit courts of appeals? Well, then a higher court in the same jurisdiction would obviously be the U.S. Supreme Court. U.S. circuit courts of appeals in the federal system, there are 13 of them, are not bound by each other's opinions because they're all of equal dignity in the hierarchy of federal courts. But of course, they are all subject to the decisions of the U.S. Supreme Court. And then finally, if you are in the U.S. Supreme Court, well, there is no higher court than the U.S. Supreme Court. So that makes it an easy decision about, are there any higher courts in the same jurisdiction? Nope. If you're in the U.S. Supreme Court, you're in the highest court in the jurisdiction. So let's look at a chart here of the federal court system. It's abbreviated, but I want to illustrate again how this this link to determine what are higher courts in the same jurisdiction would work. So at the bottom level, we have trial courts. In the middle row, we have selected courts of appeals in the federal system. And then, of course, at the top, we have the Supreme Court. Well, let's start at the bottom. Let's say that your client, you'll notice here on the chart that certain courts are linked to each other by vertical lines. And so if to the extent these courts are linked by vertical lines, they are considered in the quote, same jurisdiction, unquote. So here's an example. If your client is in a U.S. District Court in Texas, or a U.S. District Court in Louisiana, or a U.S. District Court in Mississippi, then you see here we've got a vertical connection upward to the Fifth Circuit Court of Appeals, because that's the Circuit Court of Appeals that has appellate jurisdiction over the U.S. District Courts in these 3 states. So that means then that if your client is in one of those 3 states in a federal district court, then the decisions on point from the Fifth Circuit Court of Appeals will be binding on that court. And then, of course, the Fifth Circuit Court of Appeals itself is linked upward to the U.S. Supreme Court. And so here then is what the circled courts form the same jurisdiction. Now, just note that the First Circuit Court of Appeals its opinions would not be binding on the Fifth Circuit Court of Appeals because it's not a higher court. It's an equal dignity court, nor would the opinions of the First Circuit Court of Appeals be binding on the U.S. District Courts in Texas, Louisiana, and Mississippi, because those 3 states' federal district courts are not under the appellate jurisdiction of the First Circuit. Now, I didn't have room to put all the circuit courts of appeals. So this next box to the right that I'm putting an X through is supposed to represent the second through fourth circuits. But again, their opinions would not be binding on either the Fifth Circuit or the U.S. District Courts in Texas, Louisiana, and Mississippi. And then on the right side of the Fifth Circuit Court of Appeals is that box is supposed to represent the 6th through 12th circuits. And again, those opinions from those courts would not be binding on the Fifth Circuit Court of Appeals or on the U.S. District Court sitting in Texas, Louisiana, and Mississippi. And finally, the 13th Circuit Court of Appeals, also known as the Federal Circuit, similarly would not be binding on the Fifth Circuit or the U.S. District Courts in these 3 states. So if we just kind of erase those inapplicable circuit courts of appeals, now we have a picture of the same jurisdiction when you're looking at from the perspective of U.S. District Courts sitting in Texas, Louisiana, and Mississippi. All right, now let's shift to the Texas court system. What constitutes a higher court in the same jurisdiction in the Texas court system? So let's do the same thing we did with the federal court system and pull up a chart here where on the left-hand column, we'll describe the court that your client is currently in, and then to the right, we'll identify what would be the higher courts in the same jurisdiction for that court. So if your client is in a Texas district court that is a state level, not U.S. federal court, or a county level court, such as a county court at law, statutory probate court, and so forth, then the higher courts in the same jurisdiction would be first the Texas Intermediate Court of Appeals that would have jurisdiction to hear the appeals from that particular trial court. Again, not all 14 of Texas's intermediate courts of appeals opinions will be binding. It would be of those 14 courts of appeals, it would be only the one that has appellate jurisdiction over the particular trial court that your client is in. Now, of course, the Texas Supreme Court is a higher court in the same jurisdiction. So if your client is it has a civil case in a Texas district or county level court, then the Texas Supreme Court's opinions would be binding on that court. By contrast, if it's a criminal case pending in one of those trial courts, then the Texas Court of Criminal Appeals, which is Texas's supreme level court for criminal appeals, its opinions would be binding on the trial court. Now, finally, I'm going to list the U.S. Supreme Court. Now, the U.S. Supreme Court is technically in the federal court system, whereas this chart is geared toward the Texas court system. However, if you have a case that originates in the Texas court system, typically, if you want to appeal, you have to appeal through upward through the Texas court system. You can't hop over to the federal system and back and so forth. But there is an exception. If you have a case that originates in a Texas court system, in a Texas trial court, and it involves a U.S. constitutional issue of some kind, such as the constitutionality of a statute, then you could work your way up through the Texas appellate court system, and then after the highest court in Texas has ruled on it, the losing party would have the option, because the case involves a U.S. constitutional issue, to seek review of the highest court, Texas court's opinion in the U.S. Supreme Court. And of course, U.S. Supreme Court has discretion to hear the appeal or not to hear the appeal. But so I'm putting the U.S. Supreme Court among the higher courts in the same jurisdiction for these Texas courts, even though it's technically a federal court, because of this this sort of exception that U.S. Supreme Court would still have appellate jurisdiction to review decisions in constitutional cases issued by the highest courts in Texas. Okay, next, let's say that you are your client is in a Texas Intermediate Court of Appeals, one of the 14, such as the Dallas Court of Appeals or Fort Worth or one of the 2 in Houston and so forth. Well, then, of course, the Texas Supreme Court's opinions, assuming they are on point, will be binding in civil cases, and the Texas Court of Criminal Appeals on point opinions will be binding in criminal cases, and then also the U.S. Supreme Court would be a higher court given its appellate jurisdiction over state courts when it comes to constitutional issues. Now, finally, if you are in either of, your client is in either of the 2 Supreme level courts in Texas, either the Texas Supreme Court or the Texas Court of Criminal Appeals, then at that point, the only higher court that potentially would have opinions that could be binding would be the U.S. Supreme Court, and typically that would involve opinions on point that involve U.S. constitutional issues. So, as we did with the federal court system, now let's look at a chart of the Texas court system and see how this works in a bit more detail. So again, at the bottom, I've listed state and county trial courts in 5 different counties: Collin, Dallas, Grayson, Kaufman, and Rockwall. And now the middle row of courts is supposed to represent the 14 intermediate courts of appeals in Texas. Didn't have room to list them all, so I started with Amarillo. The second box next to it is supposed to encompass multiple other courts of appeals. I did include the Dallas Court of Appeals, and then I ended with the Waco Court of Appeals. But notice here that let's assume that you have a client who is in a trial, either a Texas district court or a county level trial court, sitting in Collin County, Dallas County, Grayson, Kaufman, or Rockwall County. Now, notice that all of these counties are joined by a vertical line with the Dallas Court of Appeals, because that is the Texas Intermediate Court of Appeals that has appellate jurisdiction to hear appeals from the Texas district and county level trial courts in these 5 counties. And then, of course, the Texas Court of Appeals itself is joined vertically to the Texas Supreme Court above for civil cases and the Texas Court of Criminal Appeals above for criminal cases. So it works kind of the same way as we saw with the federal court system. The opinions of the Dallas Court of Appeals that are on point will be binding on Texas district and county level trial courts in Collin, Dallas, Grayson, Kaufman, and Rockwall counties. And similarly, the opinions on point by the Texas Supreme Court or the Texas Court of Criminal Appeals will be binding not only on the Dallas Court of Appeals, but also on the trial courts in Collin, Dallas, Grayson, Kaufman, and Rockwall counties. Now, in the middle row, I'm Xing out the Amarillo Court of Appeals here, because the Amarillo Court of Appeals opinions are not going to be binding on the the Dallas Court of Appeals, because those are courts of equal dignity in the hierarchy. Nor would the opinions of the Amarillo Court of Appeals be binding on the trial courts in Collin, Dallas, Grayson, Kaufman, and Rockwall counties, because the Amarillo Court of Appeals does not have appellate jurisdiction over those counties. The Amarillo Court of Appeals has appellate jurisdiction over a cluster of counties in the Panhandle in its own jurisdiction. But Collin, Dallas, Grayson, Kaufman, and Rockwall counties are not among them. So again, I'm marking out all the other intermediate courts of appeals to illustrate this point. So here we have now the same jurisdiction illustrated for from the perspective of the state and county level trial courts sitting in Collin, Dallas, Grayson, Kaufman, and Rockwall counties. So the binding precedent test will be the most important one that you do. Now, sometimes you may find there's only one binding precedent, or you might find there are multiple binding precedents, or you may find that none of the cases on point that you found are binding. They would all be persuasive. Now, if you get to that point, now they're going to be where you have either multiple binding or you have multiple persuasive when there is no binding. Now you have to go to some other tests for the relative weight to determine which of those opinions your client's court or potential court would give the greatest weight to. And so here are a couple of pretty common sense distinctions. If all other considerations are equal, normally the decisions of higher courts will carry more weight than the decisions of lower courts. So if you're in a Texas court, you have no binding authority, but you have a Oklahoma Supreme Court on point, and then there's also a Virginia Intermediate Court of Appeals opinion on point. Well, since the Oklahoma Supreme Court is a higher level court than the Virginia Intermediate Court of Appeals opinion, I mean, they're not in the same jurisdiction, the court may have a tendency to give more weight to the Oklahoma Supreme Court because it's a higher level court. Now, another common sense distinction is that, again, all other considerations being equal, more recent or newer precedent tend to carry more weight than older precedent. So if you have let's say you have a persuasive precedent from a Texas Court of Appeals from 1902, and then there's another one from another Texas Court of Appeals from 1999. Again, the court may have a tendency to give more weight to the more recent case. Now, here's another distinction that potentially may crop up, and that is whether the precedent was decided by a federal court or instead a state court. Now, whether a federal court opinion will carry greater weight than a state court opinion or vice versa will depend on two factors. One is, what court system is your client's case currently pending in, or would it be pending in if it were to be filed? So that is, what is the current court system we're dealing with where the client is? And secondly, does your client's current dispute involve state law or instead federal law? So here's a quick breakdown of the types of cases that federal courts will typically rely on and give greatest weight to, and then state courts. Federal courts, if your client is, for example, in the United States District Court for the Northern District of Texas, if the client's dispute involves federal law, then that federal trial court is going to rely on the decisions of federal courts when interpreting or applying federal law. Kind of makes sense. Now, sometimes though, a case that is filed in federal court may actually involve state law. There are certain circumstances where that's possible. And so if your client's case is filed in federal court, but the dispute is governed by state law, then typically federal courts will rely on the opinions of that state's highest court for guidance on that state's laws. So in that situation, the state's highest court opinions would carry greater weight than, say, federal opinions on that state's law. Now let's flip the situation and assume that the client's case is not filed in federal court, but instead in, say, a Texas state court. Now, state courts, when they decide issues of state law, then they rely on the decisions of that state whose laws they're applying in the case. That simply makes sense. If the law governing your client's case is Texas law, well, then the court will rely on the decisions of Texas courts. Now, here's where it's a little bit odd, but sometimes you can have a case filed in state court that's governed by federal law. For example, you may have a civil rights case that arises under a federal civil rights statute, but is allowed to be brought in a state court as well as a federal court. The plaintiff gets to choose. Now, if your client's case is filed in a state court, but federal law governs the dispute, well, the state court is free to rely on decisions of federal courts regarding that federal law, but are not bound by them. So again, this gives you a little bit of a sense of in what circumstances would a state court opinion carry greater weight or maybe carry less weight than a federal court opinion, depending on what court system your client's case is filed in and what type of law governs the dispute, federal or state. Now, sometimes you may find that there are both federal law and state law that govern the same dispute that your client's involved in. And you might find on occasion that those laws conflict with each other. So sometimes you do have areas such as environmental protection in which you have federal laws that regulate that sphere of activity, and you have state laws that do the same thing. Now, if you get in a situation where these two laws are contradictory or conflict, you have what are called conflicting authorities. Now, in this circumstance, sometimes, it's not automatic, but sometimes federal law will preempt, that means trump or take precedence over the conflicting state law. Now, it is not just automatic that if there's a conflict between federal and state law, federal automatically trumps and you just move on. Rather, there is a doctrine of preemption that federal courts will follow in determining whether federal law preempts the conflicting state law. And generally, the preemption will occur if the court decides that the United States Congress, either in the wording of the federal statute or as indicated in some part in the legislative history of the statute, expressed an intent to be the only regulator of the area in question. That is, to the exclusion of state laws. And so if the court engages in this preemption analysis and determines, yeah, the US Congress did express an intent to be the sole regulator of the particular sphere of activity, then the court will be likely to hold that the federal law preempts the conflicting state law. Otherwise, state law may govern. So again, parties sometimes in this situation will file a lawsuit to ask a federal court to decide in this situation which legal system's law controls. Okay, now there are other characteristics of opinions that can also affect the relative weight that they can have with a particular court. And now we're going to be looking at types of opinions, not so much the type of court, but rather the type of opinion itself. And here is one distinction that applies only to opinions of intermediate courts of appeals. Doesn't apply to Supreme level court opinions, but only intermediate courts of opinions. Now, courts of appeals opinions. Now, if you'll recall, intermediate courts of appeals have numerous justices on them. They can have anywhere from 10 to over 20, and maybe more. But typically, though, for each appeal, only 3 of those justices on the Intermediate Court of Appeals will be assigned to hear the appeal. And this subgroup of 3 justices hearing each appeal is called a panel of justices. Now, there are, however, some extraordinary circumstances wherein, on its own initiative, the court will require all of the justices on the court to hear a particular case. And this usually happens, it's not common, but when it does happen, it usually involves an extremely important case. In addition, either of the parties to the appeal can file a motion with the court asking the court to hear the case with all of the justices on the court participating, not just a panel of 3. And of course, in that situation, the court has discretion to grant or deny that request. So now this leads up to the distinction in the resulting opinions. If the case was heard by all of the justices on the court, not just a panel of 3, the resulting opinion at the end of the appeal is called an en banc opinion. That's Latin for in bench. Essentially, it means all of the justices who sit on that court's bench presided over the case. It was not just a panel of 3. Now, by contrast, a panel opinion is an opinion issued in an Intermediate Court of Appeals case where only that 3 justices participated, or if not 3 exactly, it was not the whole group of justices on the court. And so because of this, because of the, if all of the justices are participating, then the resulting opinion, that is an en banc opinion, will carry greater weight than a panel opinion. Now, another distinction between types of opinions involves whether or not on the opinion itself the court has identified the justice by name who authored the opinion and the other justices by names who joined in that opinion. Now, if the court in the opinion does identify the name of the justice who authored it and the names of the other justices who joined in that opinion, such as in a majority opinion, then you have what's called an authored opinion. Now, all court opinions are authored, of course, but this authored opinion phrase specifically refers to an opinion where the participating justices in the opinion, the author and those who joined in it, are actually named. Now, these authored opinions are typically issued after the full-blown process of the appeal has taken place, such as after the parties have filed full appellate briefs with the court, with their citations to law and arguments and so forth, and typically after the court has conducted oral arguments where the lawyers can appear before the court in a strictly timed session and make their best case orally to the court for their clients and field any of the justices' questions. Because of the authored opinions typically are issued after full briefing, full oral arguments, the full scope of the typical appellate process, authored opinions are commonly carry greater weight than the other type of opinion that I'm comparing it to, and that is the per curiam opinion. So let's look at what a per curiam opinion is, because an authored opinion typically carries greater weight than a per curiam opinion. Now, per curiam is a Latin phrase meaning by the court. Now, an opinion, a per curiam opinion, is an opinion in which the court did not identify by name the justice that authored it or the justices that joined in that opinion. Instead, the court simply noted at the top of the opinion the Latin phrase per curiam. Now, what this designation does is signify that here the court was issuing the opinion uh, simply as an institution where the individual justices who authored or joined in it are not named. It's simply issued by the court as a block or institution, hence the Latin phrase per curiam, by the court rather than, say, named justices on the court. Now, per curiam opinions often are shorter than authored opinions, and often they involve relatively uncontroversial issues. And sometimes they are issued without requiring full briefs to be filed by the parties or oral arguments to be made by the attorneys. And so often because the court or a majority of the court is easily persuaded that this is a case that doesn't even need to go into that kind of, it would be a waste of time because the court believes that either the issues or the circumstances are relatively uncontroversial, and therefore there's no need to go through the whole typical appellate process. And so now, so because of this, per curiam opinions tend to carry less weight than authored opinions, and they do tend to be shorter, although there certainly are, longer per curiam opinions, such as by the U.S. Supreme Court and so forth. But in general, your authored opinions are going to carry greater weight than a per curiam opinion. Okay, now another distinction that can be made among opinions when you're trying to assess their relative weight is the number of justices who agreed with each other or didn't agree with each other in the case. Now, let me give you a little bit of background to how this works. When justices on an appellate court or supreme level court decide a case, you have more than one justice deciding it, whether it's a 3-person panel on an intermediate court of appeals, whether it's an en banc proceeding with all the justices on the intermediate court of appeals, or whether it's all the justices sitting on a particular supreme level court. When they decide a case, the justices have to determine the extent to which they agree on 2 aspects of the decision. The first is the result to be reached in the case. That is, like the holding, or even maybe as narrow as what's the disposition to be? Should the lower court's opinion be affirmed or should it be reversed? So we're talking about here, they first have to decide, do they agree on the last word, on the final decision itself, the conclusion or procedurally the disposition of the lower court's judgment. But there's another aspect that they have to determine whether they agree on, and that is, even if they agree on the result, they have to then determine, do they agree on the legal reasoning leading to the result? Because you can have some justices that that you could have a court that's unanimous, for example, that the lower court's judgment should be affirmed. But you may not have unanimous agreement as to the legal reasons why. Some justices may think that the decision should be affirmed for certain legal reasons, and the other justices may think it should be affirmed for different legal reasons. So they're getting to the same result, but by different legal reasoning tracks. So you have 2 aspects of the decision that the justices on appellate courts have to determine the extent of their agreement on. So as a result, these justices can potentially agree with each other on both the result and the reasoning, on just the result but not the reasoning, or they can disagree on neither the result nor the reasoning, meaning they disagree with each other totally on everything. Now, if more than half the justices on the court agree on both the result and the reasoning, then they will join in what's called a majority opinion, because it is more than half the justices who heard the case that agree on both the result and the reasoning. And in that situation, the majority opinion will constitute the official decision of the court. It's kind of a majority rule situation. Now, if you have a majority in that, like that, well, what about the remaining justice? What about the minority of justices? Now, typically in that situation, if they're not joining with the majority, then that means that they disagree with the majority's result, or they disagree with the majority's reasoning. And so these remaining justices will normally author separate minority opinions to express their points of view, either why they disagree, why they think the majority got to the wrong result, and that necessarily means they think they used the wrong reasoning. But even if the minority of justices agree with the result reached by the majority, then they would typically author their own minority opinion to express why they think the majority's reasoning was wrong. And then these minority of justices will explain what they think the correct legal reasoning should have been. So with that background, we can now look at the categories of opinions based on the number of justices who heard the case that agree with each other or disagreed with each other, and on what grounds. So and I've listed these types of opinions in descending order of weight. So the first type of opinion here, unanimous, will carry the greatest weight among these 5 different types, and then it typically goes down in terms of weight from there. So a unanimous opinion is an opinion that is joined by all the justices who heard the case, and all of the justices agree on both the result and the reasoning. And believe it or not, there are unanimous opinions, even by the US Supreme Court. Now, a majority opinion is an opinion joined in by more than half the justices sitting on the court, and those more than half of the justices agree on both the result and the reasoning. Now, a plurality opinion arises when you have more than half of the justices who hear the case agree on the result, but you don't have more than half agreeing on the reasoning leading to that result. We call this a plurality opinion. It works in a lot of ways like in an election. If you have a candidate who gets what you might, let's say there are 3 candidates, and you have a candidate that doesn't get a majority of the votes, that is, 51%, but gets, say, 40%, but that's more, or let's say 48%, and that's more than either of the other 2 candidates. You would call that a plurality uh, uh, count. So it works. The plurality opinion works this way in a similar fashion. It's where you have more than half the justices that agree on the result, such as to affirm the lower court's judgment, but you don't have more than half agreeing on the reasoning. So it carries a little bit less weight than a majority opinion, because even though you have a majority agreeing on the result, there's not the same level of agreement on how legally you got to that result. Now, these last 2 opinions are minority opinions that would be in response to a majority opinion. So a concurring opinion is an opinion by a minority of the justices. That is, You have a majority of the justices over here who agree on both the result and the reasoning, but now you have a minority, such as 1 or 2 or 3, who agree with the majority on the result, but disagree with the majority on the reasoning leading to it. So in other words, this minority of justices agree or concur with the majority's result, but they disagree with the majority's reasoning. Now, finally, the dissenting opinion would also be by a minority of justices in response to a majority opinion. And these minority of justices would disagree or dissent from the majority opinion regarding both the result and the legal reasoning of the majority. So this is the breakdown and the relative weight that these types of opinions can have. So just graphically, I'm going to give you a couple of examples here that I hope will make this clearer. Let's say that you have 9 justices that hear a case, such as on the US Supreme Court. And they, at the end of the day, they vote and determine to what extent they agree or disagree. And here is the result. Of the 9 justices, 5 of them agree with each other on the result, and those same 5 agree with each other on the reasoning leading to that result. So one of them takes the lead, drafts an opinion, and the other 4 justices join in. So you have 5 justices all on board with this opinion. That would be a majority opinion. More than half of the justices agreeing with each other on both the result and the reasoning. Okay, well, we still have 4 justices left. What about the next 2? Well, the next 2 agree with the majority on the result, but they think the majority used the wrong legal reasoning getting to that result. So these additional 2 justices then join in a separate minority opinion in which they explain what they think the proper legal reasoning leading to the result was. Well, their opinion would be called a concurring opinion because they concur or agree with the result of the majority, but they disagree with the reasoning used by the majority, and so they issue a minority concurring opinion. Now, finally, the last 2 justices on the court, let's say that they disagree with the majority regarding the result, and they disagree with the majority regarding the reasoning. Now, typically, if justices disagree with the majority on the result, then it just logically follows that they disagreed with the legal reasoning leading to it. But in any event, you have the final 2 justices disagreeing with the majority on both the result and the reasoning. They author their own minority opinion explaining what they think the proper result and, of course, the proper reasoning should have been, and that would be a dissenting opinion. So that's an example of how this would work. One more example. Let's say, again, we have 9 justices who hear a case, and at the end of the day, they're reaching their decisions and determining to what extent they agree with each other on the result and the reasoning. Here is the ultimate breakdown. Let's say you have 4 of the 9 justices who agree with each other on the result, and these same 4 justices agree with each other on the reasoning. Well, 4 is not a majority of the court. Well, let's keep going. The next 2 justices agree with the first 4 justices on the result, but they disagree with the first 4 justices on the reasoning. And finally, let's look at the last 3 justices. They disagree with all 6 of the justices above on the result, and they disagree with all 6 justices above on the reasoning. All right, Notice here, though, we don't have a majority of justices agreeing on both the result and the reasoning. What we do have, though, is we have 6 of the justices agreeing on the result. The first 4 and the second 2 all agree with each other on what the result should be, such as affirming the lower court's judgment. So that's what will happen. We have a majority saying the lower court's judgment should be affirmed. So that will be of course, that will be the result. But notice, though, that when it comes to the reasoning, we do not have a majority of justices agreeing. So here it's a bit split. We have a majority agreeing on the result, but no majority agreeing on the reasoning leading to that result. So what would happen? The first 4 justices would author their opinion, explaining their reasoning leading to the result. The second, the excuse me, 5th and 6th justices listed here would issue their opinion, which would state the same result as the first 4, but give a different legal reasoning for it. This is a situation that is called the plurality opinion. You have majority agreeing on result, but no majority agreeing on the reasoning. And you wind up having really 2 separate opinions that support the result, but the reasoning is not, there's no majority of the reasoning. And so this, a plurality opinion is a bit weaker than a majority opinion, because in a majority opinion, you have a majority of the justice agreeing on both the result and the reasoning. Here, with a plurality opinion, though, you have a majority agreeing on the result. It's a bit shakier, legally speaking, because you don't have a majority agreeing on the legal reasoning. Okay, now there is another distinction between types of opinions, and I'm gonna have to break it down into how it's done in Texas Intermediate Courts of Appeals, and then how it's done pretty much in other courts. But it's basically the difference between an opinion versus a memorandum opinion. So first, let me address how this distinction is handled in Texas, and this distinction applies only to Texas Intermediate Courts of Appeals opinions. In Texas Intermediate Courts of Appeals, an opinion is an opinion, of course, that in which the Intermediate Court of Appeals does at least one of the following things: establishes a new rule of law, alters or modifies an existing rule, or applies an existing rule to a novel fact situation that is likely to recur in a future case. Or the court addresses issues of constitutional law or other legal issues important to the jurisprudence of Texas. Or the court criticizes existing law, or the court resolves an apparent conflict of authority, such as if several courts have different courts have come up with conflicting results on a particular issue, and in this opinion, the court is trying to resolve the conflict in some way. That would qualify this to be an opinion. And so, in other words, what's happening here is in the Texas Intermediate Courts of Appeals, if the court in the opinion does something important beyond simply applying rules of law to the facts to reach a conclusion on the party's dispute. In other words, if the opinion does something, has greater significance for the law or the state of the law in some way, that it extends the law or enhances our understanding of the law, in that sort of sense, or addresses a really important issue in the law, then you have what's called an opinion. And so the Texas Rules of Appellate Procedure require now Texas Intermediate Courts of Appeals to designate every one of their opinions as either an opinion, which would have to meet this standard here. It has to do at least one of these important things listed here. Or, and here is the other type of opinion. The Texas Court of Appeals would have to designate the opinion as a memorandum opinion instead. So it's got to have the word opinion at the top or memorandum opinion at the top. Well, a memorandum opinion is simply an opinion by a Texas Intermediate Court of Appeals in which the court did none of the actions that I listed on the previous slide. So in other words, it's typically application of routine or uncontroversial rules of law to facts that are not novel, not new, not likely to recur in the future, and therefore really doesn't contribute much to the development of Texas law, or does not deal with a really important issue like constitutional law and so forth. So that would be a memorandum opinion. Now, as you can imagine, an opinion carries greater weight than a memorandum opinion, simply because of the content of the opinion. Now, we still have this distinction between opinion and memorandum opinions in courts other than Texas Intermediate Courts of Appeals. And so I want to go ahead and let you know what it is. It's a little bit simpler, but once you get outside of Texas Intermediate Courts of Appeals, an opinion is pretty much a document that we think of as a court opinion generally, in which the court discusses the reasons for how it ruled on the appeal and its disposition of the lower court's judgment. Pretty much what court opinions do. However, outside the Texas Intermediate Court of Appeals context, a memorandum opinion, that phrase is commonly is used to refer to a document in which a court states its disposition of the lower court's judgment only without explaining why. So this is a distinction that you may see in other courts outside of the Texas Intermediate Courts of Appeals. And of course, as you can imagine, a memorandum opinion has no weight because all it does is state the disposition, that the lower court's judgment is affirmed or reversed, but it gives no reasoning or explanation. So it really has almost no use in terms of case law, whereas an opinion would certainly have a greater weight. Now, another distinction that can affect the weight of cases is whether the case is published. Now, as a reminder, a published opinion is an opinion that the court has designated to be published in the applicable case reporters for the court or jurisdiction, and ultimately in the hardbound reporters. Now, an unpublished opinion, by contrast, is an opinion that the court has designated not to be published in the applicable reporters for the court or jurisdiction. Now, I want to talk about first the federal courts and then Texas courts about the policies of designating opinions as to be published or not to be published, because certain courts are required to designate all their opinions for publication. Other courts have discretion and so forth. So quickly, let's look at how the federal court system does this, starting at the top. The U.S. Supreme Court designates all opinions for publication. Makes sense. And that's according to the Supreme Court's own rules. Now, in the federal circuit courts of appeals and in the United States district courts, the trial courts, because U.S. district judges do sometimes author opinions to support rulings on motions and so forth. These two federal levels of courts have discretion to designate their opinions on a case-by-case basis as, do not publish or publish. And so um, under the Federal Rules of Appellate Procedure, unpublished opinions by these two courts may be cited as authority to federal courts if the opinions were issued from January 1st, 2007 to the present. If an unpublished opinion is earlier than January 1st, 2007, it may not be cited as authority to a federal court. Okay, now let's look at Texas, how Texas has handled the publication issue. Now, the Texas Supreme Court designates all of its opinions for publications per the Texas Rules of Appellate Procedure. By contrast, the Texas Court of Criminal Appeals has discretion to designate opinions as do not publish. Now, one thing to know about unpublished Texas Court of Criminal Appeals opinions is that you may not cite those unpublished opinions as authority to a Texas court at all. The Texas Rules of Appellate Procedure provide for this. Now, when we get to the Texas Intermediate Courts of Appeals, as always happens with the Texas Intermediate Courts of Appeals, things get a bit more complicated because the rules changed. Before January 1st, 2003, the Texas Intermediate Courts of Appeals, the 14 of them, had discretion to designate their opinions on a case-by-case basis as do not publish. So if you want to cite an opinion of a Texas Intermediate Court of Appeals that's unpublished and was issued before January 1st, 2003, whether it was a civil or a criminal opinion, you may still cite it as authority to a Texas court, but these opinions cannot be binding authority, even on the court that issued them. Further, if you do cite an unpublished opinion by a Texas Intermediate Court of Appeals that was issued before January 1st of 2003, at the end of your citation to the case, in parentheses, you have to put the phrase not designated for publication so that the reader, for example, the judge, will know that this is a case that cannot be binding authority. At best, it can be persuasive. Well, beginning January 1st, 2003 and continuing to the present, things are a bit different. Now, for criminal cases issued by the Texas Intermediate Courts of Appeals, there is no change. For criminal cases, the Texas Intermediate Courts of Appeals can still designate them do not publish. And if you want to cite a criminal case by a Texas Intermediate Court of Appeals, it's not going to be binding authority, and you have to put not designated for publication at the end of your citation. But for civil cases issued beginning January 1st, 2003 to the present, the Intermediate Courts of Appeals no longer designate the opinions as to be published or not to be published. Instead, they designate each civil opinion as either an opinion or a memorandum opinion, as we just saw earlier. Now, typically, those opinions designated as memorandum opinions by these Texas Intermediate Courts of Appeals are not published. They will not appear in the Southwestern Reporter. Now, all opinions issued by Texas civil cases issued by Texas Intermediate Courts of Appeals from January 1st to 2003 are going to be binding authority on the relevant courts. So there was a change here, and the change really effective January 1st, 2003. the civil cases or opinions issued by Texas Intermediate Courts of Appeals. If it is an opinion by a Texas Intermediate Court of Appeals issued after January 1st, 2003, it will be binding on the relevant courts, regardless of whether it's a memorandum opinion and regardless of whether the opinion appears in the Southwestern Reporter. And finally, if it is an opinion that does not appear in the Southwestern Reporter, a citation to a civil case that it was issued January 1st, 2003 to present does not have to include the parenthetical notation not designated for publication at the end, because they're all binding authority on the relevant courts. Okay, now this is a bit more of an obscure distinction. I'm going to point it out anyway, and it has to do with appellate court opinions or Supreme Court opinions that are on the merits of the issues in the appeal at the end of the day versus opinions supporting some interlocutory order by the court in the meantime. So let's get a handle on the distinction here. An opinion on the merits of the appeal is a final opinion by the appellate court setting forth the court's reasoning and conclusions regarding the lower court's alleged errors and explaining why the appellate court is going to reverse the lower court's judgment or affirm it and so forth. In other words, an opinion on the merits of the appeal is what we usually think of as an appellate opinion. And but by contrast, an opinion related to an interlocutory order is an opinion by an appellate court that explains the basis for its interlocutory order. Now, an interlocutory order is a ruling typically on a party's motion during the pendency of the appeal, requesting the court to take some procedural action before the court has issued its final opinion on the merits of the appeal. So, for example, if you have one of the parties that files a motion for an extension of time of the deadline to file the appellate brief, the court may grant it or deny it. That order, granting or denying the motion, would be an interlocutory order. And if the court wants to, it could issue a brief opinion explaining why it granted the motion or denied the motion. Well, that opinion explaining why the court denied the motion or granted it would be an opinion related to an interlocutory order. Or another type of interlocutory order is on a party's motion to stay or suspend enforcement of the trial court's order or decree until the appeal has concluded. Now, again, it's called an interlocutory order. Interlocutory sort of etymologically means speaking between. So it's referring to an opinion supporting an order of the court occurring after the appeal was filed, but before the court issues its final opinion on the merits of the real issues raised in the appeal and that will govern the court's disposition of the lower court's judgment. So it's occurring in between these two bookends, and therefore is called an interlocutory order, and the opinion explaining the order is called an opinion related to an interlocutory order. So again, most of the opinions you'll be looking at that are appellate court opinions will be on the merits of the appeal, and they carry more weight than an opinion related to an interlocutory order. Okay, so this chart here is purely for your convenience to summarize these various points of comparison when deciding the relative weight of your cases on point when you're trying to decide which of these cases on point will your client's court or potential court most likely give the greatest weight to, such as binding precedent versus persuasive, opinions by higher courts versus opinions by lower courts. and so forth. So this is just to try to pull it together in a chart so that you can see at a glance what the key distinctions are that can affect the weight that a case on point will be given. Okay, now finally, the sub-step C in analyzing cases to determine which will be the most appropriate to rely on in your legal research as governing your client's issues and so forth, has to do not with comparing cases to each other in some way, but instead within each case on point, which statements by the court carry the greatest weight as authority and which carry the least weight. Not all statements in a single court opinion carry equal weight. So the key distinction I want to bring to your attention here is the distinction between the court's holding sometime or conclusion of IRAC on the one hand and dicta on the other. So the most important statements in a court opinion are going to be the holdings. Or courts, if there's one issue, there'll be one holding. If there are multiple issues, there'll potentially be multiple holdings. And these are also known as conclusions. And so this should be very familiar to you because holdings or conclusions are the court's direct answers to the issues raised by the parties on appeal. That is, the court's conclusions regarding the legal effects of the relevant facts in the case. So these holdings or conclusions form the C of the IRAC analysis. And so, as I mentioned, if a court has to address multiple issues in an opinion, which is common, then typically the court will engage in the IRAC pattern of legal analysis for each issue. I for issue, R for rules of law, A for application of those rules of law to the relevant facts of the case, and then C is the conclusion drawn from the application process, and that forms the direct answer to the issue. That's the IRAC pattern of reasoning. Now, the holding of the case is often seen as the proposition for which the case stands. And of course, if a case has multiple holdings, it can perhaps stand for multiple propositions. So these holdings or conclusions are the most important statements in the opinion. Now let's look at the least important statements in an opinion, and they're called dicta. Now, dicta are statements in a court opinion regarding some issue, fact, rule of law, and so forth that are not directly relevant to the party's actual issue or circumstances in the case. Now, to help you understand what dicta are, it helps to understand what the word means in a Latin sense. Dicta is the plural form of the singular noun dictum. Now, we see the word dictum a lot in the Latin expression obiter dictum, which means something said by the way, kind of like an offhand comment, a comment that is not directly relevant to the issues or the parties, but that the court is kind of an aside that the court may make. Now, not all cases contain dicta. So, you know, but some do, and it's good if you can recognize it and not slip into the error of thinking that dicta are going to be very authoritative. In fact, dicta are not binding authoritative. They have no binding authority at all, even on the court that made the dicta. But you can cite dicta as persuasive authority. Now, here are just a couple of examples of dicta, how you might typically see dicta in a court opinion. A court might, for example, in its analysis of a case, might formulate a hypothetical factual situation. Well, it might formulate a hypothetical factual situation sometimes that has elements that are different from the fact situation that the actual parties have. And the court might do this to help illustrate um, reasoning, to help contrast this case from other possibilities, whatever. But if you have a hypothetical boast by the court that is different from the party's actual situation, that's most likely going to be dicta. And the court might introduce this, for example, by saying, if we were presented with this other type of issue or circumstance, but we're not, then we might have done or ruled some way. But that's not what we're dealing with here. You might have that kind of statement in the opinion. That would be an example of dicta. In addition, sometimes courts will give you a little history lesson about a rule of law or a doctrine, the evolution of a particular doctrine, which can be very helpful to understand it, but is not necessarily it's not necessary to the court's reasoning to give you that background. And so sometimes that can be dicta as well. So these are just some examples of dicta, but just remember that dicta are never binding authority. They can only be persuasive authority, even on the same court that wrote the dicta. Okay, well, that brings us now to a close of our case law selection and analysis discussion, and I appreciate your listening.